So I guess the first thing to know is, you have to sort of be aware of when you have an end of life decision and what's happening with these individuals. So you have to be on top of it, and usually the sooner we know, the better. So if we could have the next slide, please. So much of what we do, there are statutes, is the Uniform Probate Code, which gives us some guidance. But a lot of what we're doing is based on case law. So that's the court, the Supreme Judicial Court in Massachusetts, deciding generally just individual cases. And then we try to apply that to the facts and circumstances that you provide for us and the individual that we're dealing with. That can get kind of interesting because some of the cases are quite old. The DNR DNI case, the first one I think was from 1983, Carol, if I remember that correctly. So we're trying to apply today's medical technology and facts to that case from 1983.
Yeah, I actually think it's older, Jim. I think it might be, if we're talking about Dinnerstein, I think it's from the 70s. And what's interesting about the case is they talk about the new diagnosis of Alzheimer's disease in that case because it had just been diagnosed.
Yeah, so we're interpreting old case law, and it's often very fact specific to the circumstances of that individual and their families. And then there's some assistance with the regulations, and then also policy. We do have an end of life policy that DDS has, and my understanding is it's about to be or is being redrafted or
Yeah, and I
revised.
think some of the ABI nurses may have been, because I know nurses were invited by Dr. Dreyfus to a meeting to talk about it. We're actually giving it a new name. I think it's something about end of life. It's about something about choices for, I can't remember the name, but it's going to be called something different, and it's going to be basically the same principles of the end of the current policy, but it's going to be a lot shorter because there was a lot of repetition in it.
Yeah, I want to say it was referred to as life-sustaining treatment. And the way it was viewed is you can't withhold that life-sustaining treatment except under certain circumstances. So that's being revised, and hopefully that can be sent out. I don't know what the timeline is on that, but that we can share as soon as it's made available. So it's all these things that go into preparing these types of cases. So if we could have the next slide, please. So I think this is sort of what we were just saying. There's lots to these cases. And this sort of just suggests that with different layers of different information that we need. And again, each case is a little different. They may sound the same. They may have a lot of the same presenting issues, but they're almost all a bit unique. So if we could go to the next slide, please. So again, we have to apply all those different aspects to it. And so when someone's under guardianship, you can go ahead to the next one. Thank you. So with guardians, it does tend to get complicated. Guardians can consent to just routine medical care, for example, vaccinations, prescriptions, pretty much anything sort of normally done. However, the case law tells us that they cannot make extraordinary medical decisions. And again, that's not really well defined. That comes from the case law. So we're left trying to figure out what's extraordinary. It's not necessarily what you might think, because a lot of medical procedures now are pretty routine that when these case laws came out were kind of extraordinary. So that the medical landscape is changing a fair amount. But guardians generally do not have the authority to enter DNR, DNI, and do not hospitalize orders.
So Jim, it might be helpful if we gave some examples of things that have been determined to be extraordinary. Like one is treatment with antipsychotic medication.
Yeah, that's clearly the one, the Rogers. Everyone refers to them Rogers because Ruby Rogers was the lead plaintiff in that case. Because of the long-term permanent side effects of the antipsychotic medications, we always have to go to court for anyone under guardianship who's going to get an antipsychotic medication. Even if it's a PRN medication, for example, we would still have to go to court.
Yeah. And treatment with electric, like ECT treatment.
Yeah, ECT and also any kind of sterilization that would require going to court. And then there's everything in between. There are obvious ones. You're going to get a quadruple bypass, cardiac bypass surgery. That's clearly highly invasive. But then you go down to things, perhaps laparoscopic surgery might not require that. So there's a whole middle ground where it's always good to discuss the case with the team and with the nurse and with either me or Carlos to sort of get an idea if it's in that middle zone. But there's some that clearly require court intervention, and those are some of them.
Yeah, and end of life, of course, is one that requires court intervention, except like we'll get into it, but it mostly does. So that's why we're talking about substituted judgment and anything that's sort of like I think one of the reasons why we can't give you firm answers is because, as Jim explained at the beginning, we're looking at case law. Like there are only been a few cases that have been decided, and they're pretty old. And so we have to kind of try to draw a rule or try to figure out what a court would do based on these old decisions. So lots of times you'll ask us, is this the kind of thing that you need to get a substitute, you have to go to court for, you need a substitute judgment, and we're just making our best guess based on the handful of cases that have been decided, and lots of times we can't predict it, and different courts might respond to different things. So I know sometimes it must be frustrating that you ask the lawyer you ask a question and we can't really give you a straight answer, and it's because we don't really know. We're just trying to make our best guess.
Yeah, and I think at least one of the cases involved the exception, or where the exception came from for DNR DNI was a person who was diagnosed with basically a terminal illness, and the family was all on board. And if I remember the facts correctly, all the family members were physicians. So it was sort of easy for the court to say, well, everyone's in agreement and everyone's highly trained and knows what's going on and knows what's happening in this case. So we take that, and that's one of the possible exceptions. Can't say it's always an exception for a DNR DNI, where the family is the guardian or family member, and the entire family is in agreement that this is what the person needs and would want and makes sense medically. So that's one of the exceptions where we might not need to go to court for an end-of-life case. But again, it's very fact-specific about the family, the diagnoses, maybe to a lesser extent in that case, what court it is. Again, unfortunately, they're not uniform. They're a little bit different. But that's the potential exception of not having to go into court. But we would all require the same amount of information from the team and from the nurse to help decide whether in fact that's a case where we didn't have to go into court to try to have the court make the decision versus the family and the team making the decision. Anything to add to that, Carol?
No, that's it. But I'm sure you all have heard us say that many times. Is it a loving family member guardian? And that's what we're always. And sometimes we can't tell. Like you'll tell us about an end of life case, and you forget that the lawyers, we don't have any information usually about whether a person is under a guardianship or whether their family's involved. So very often you'll get a response for us saying, can you tell us a little bit about the family and the situation? And then if it's a loving family member guardian, we can talk about whether we might not have to take this to court. So.
Right. So could we have the next slide, please? So this is referring to the Uniform Probate Code. And it sort of just outlines partly what we were just saying about the limitations of a guardian. So you can't have authority to like admit people to psychiatric hospitals anymore. The courts used to fairly routinely allow that. And they even used to allow a pickup order on a person who was refusing to take their antipsychotic medications. So that went away probably 15, 20 years ago. There were a few of those floating around. Can't admit them to the nursing homes. So if they don't already have that authority in the decree of guardianship, we would have to go to court to expand authority. Similar process that we would do for a DNR, DNI, and a life case. So we go to the next slide. So this is what the courts will do. It's a bit of a fallacy, but the court tries to decide what would this individual choose to do if they had capacity. So the person under guardianship has already been adjudicated as not having the capacity to make medical decisions and make end-of-life decisions. So it's the court, the judge, who's put in this position of trying to figure out, well, what would they decide if they could, and what would they tell us if they could? So it's called substituted judgment. And it does get a little bit complicated. There are basically, depending how you cut it up, 5 or 6 factors that the court has to consider when these cases come before them. And most of that requires a lot of information from you guys so that we can present that to the court. But you can go ahead and do the next slide, please.
Yeah, I was going to say that just to add to that, the court puts for the substitute judgment determination, the court is putting itself in the position of the incapacitated person and trying to decide what that incapacitated person would decide if they were competent to decide. So they have to know a lot of information about the person, about their family and circumstances and religion, to be able to put themselves in the shoes.
Yeah, and here's some of the examples that Carol had mentioned before of when we know we have to go to court. There's no question you can't do these things and not go to court. So sterilization, and what they've done, we've got here is the name of the case and how we lawyers look up cases if we don't already have copies of them. The numbers show us, and you can see they're older cases. So removal of life sustaining, that we got a case from 1986. So again, in those other 2 cases, I think are even older than that. The Spring and the Sakowitz are older than that. So most of us, we already know what these cases say and sort of what they mean and how the probate court is going to interpret them and what information we need to provide if the situation matches up with the facts in some ways with some of these cases. So there's, again, it's not a bright line rule. It's interpreting these cases, which often they're, I'd say, at least 10 pages long. So there's a lot of information in these cases. And so there's some interpretation that needs to go in with our determination of whether or not to go to court. And again, Rogers, that's clear. Everybody's familiar with that. And those cases also require an annual review of the treatment with antipsychotic medications, both to make sure, sort of monitor the potential for those permanent side effects and to see if the person still needs it or if the medication get reduced to lower the risk of those side effects.
So, I just thought of another instance when we go to court a lot for substituted judgment, that it just because it comes up a lot, is for amputations.
Yes, that does come up quite a bit, especially you get folks that get injuries of circulatory problems or diabetes, toes, typically, or a foot, or that kind of thing, it's not as uncommon as you might think. So that we need to know that, because that's pretty invasive procedure to remove part of a person's body. So those almost, I can't think of an example where we wouldn't go to court. Again, I guess one big exception is an emergency, right? So the medical people define that, we don't. If it's an emergency, someone's injured in a car crash or something, and they need to do something, then the doctors decide that that's an emergency and they can go ahead without court authority. Again, life-saving emergency, that's allowed. So if we get the next slide, please. So these are some of the end-of-life cases. Oh, Carol's right, Dinerstein, 1978. So that's the sort of the DNR, DNI case. They refer to it in the case as DNR, but at that time, DNR was considered DNI was part of DNR. So there was no distinction between resuscitation and intubation at that point. It's the medical profession has sort of added that as somehow distinct. So we ask for that separately.
But that actually could, that explains why sometimes you might get conflicting information from a lawyer or confusing information from a lawyer, because we know from Dinerstein that loving family member guardians can enter a DNR order because the court made it clear in that case, but it's not clear whether they can do a DNI, because at the time, the medical profession didn't distinguish. And some lawyers think that you can read the whole case, many pages long, and you can extract from it saying, well, because DNR and DNI were the same order back in 1978, and because they talk about her breathing problems, then like you can make an argument that loving family member guardians could do a DNI, but the more conservative position is DNR. And we often take the more conservative position because, we're trying to protect the agency from being sued, right? So we'll often be more conservative and say we only know about a DNR, and for a DNI, we're going to have to go and get a court order.
And as you can see, these are all pretty old cases. So there aren't really a lot of recent cases that address a lot of this, the end-of-life decision-making. So we're left reading these old legal cases. Go to the next slide, please. So this is a reference to an even slightly older case. And what is happening with the individual. Again, this gentleman the question came down to whether or not he should get chemotherapy. He was adjudicated as not able to make his own decisions. And so the whole medical picture, we bother and harass you guys for a lot of medical information, because the underlying sort of baseline condition of the individual is really important to help when we present it to the court. The court is going to want to know, why do we want to withhold some kind of life-saving treatment? And the underlying health condition of the individual is really important, as you might expect. If the person is declining and has all sorts of other medical issues that would make any kind of heroic efforts not necessarily fruitless, but they might not be able to get back to baseline because of all the underlying medical conditions. So a lot of times that's really key with what's going on before we get to the sort of end-of-life question. They may have all sorts of chronic health problems that are really important factors to consider. So go to the next.
So just a minute on the Sakowicz one is what I think is interesting about this one, and maybe a little bit different from some of the other cases, is that in this case, they wanted to withhold treatment. So he's older, he's got a lot, you can see he's has this, he's diagnosed with leukemia. You know, there's going to be side effects. I believe he had other underlying medical conditions, if I remember correctly, too. And so he was saying, I believe in this case, he was saying he did not want the treatment, even though his doctors were recommending it because it was the only treatment. And because the treatment was being withheld, it had to go to a judge decision. I think, today, if we get a case and someone's going to have routine chemotherapy because they have, say, breast cancer, and that's sort of the standard of treatment, I think we might not need to go to court for something like that, for chemotherapy after surgery for treatment of breast cancer, because that's kind of the expected treatment. But in that case, withholding treatment is the thing that's unusual, like declining treatment. We don't get so many cases about where people want to decline treatment. Mostly it's we're getting permission to do the treatment.
Yeah, I think that's true. I think I did have one. We had one in Central West recently. A woman was declining dialysis, and she had some underlying issues. She actually appeared and testified very eloquently of why she didn't want the dialysis, because that can be really pretty intrusive in one's life if you have to sit in a chair for 6 to 8 hours a day, hooked up to these machines. And the court, it was fairly, I don't want to say easy, that's not really the right term, but it was the court made the right decision and allowed her to forego treatment via dialysis.
Because one thing is that even if you have, so in these cases, there's a guardian and then there's a court who's making a decision for, like in Jim's case, for the woman who didn't want dialysis. But the way they're supposed to make their decision, like the way the guardian's supposed to decide, is they're supposed to give a lot of deference to what, if the person can express what they want, you're supposed to do what they say they want, as long as it's not irrational, basically. So if they can express it, and then when the court makes a substituted judgment determination, again, what the person wants is given a lot of weight.
Right. Yeah, I think that's always really important. And it can get challenging when the person's not able to communicate or communicate very clearly, or even doesn't understand what the options are. But the person has the right to refuse treatment just like you or I would, or accept treatment, again, unless it's just completely irrational and there aren't any articulable factors that the court can say, yeah, it makes sense that the person would want this. We don't have to agree with the person's choice or the court's decision. That sometimes can get challenging when, the team thinks, oh, well, they should get this, but the person is adamant that they don't want it. And so it's at odds with what most of us would think they want, but the court will probably defer to them unless it's just irrational. People have the right to refuse treatment. So if we could have the next one, please. So this is more what Carol was talking about, of being able to reject treatment. Again, the court has to go make that decision. You can't just go on the person's word that they don't want X, Y, or Z treatment if that's what's being recommended, and that's the sort of the standard of care that the doctors are recommending. We can't just allow them to turn it down without going to court, and because it's really a decision up to the judge ultimately. Again, really important what the person feels and thinks and what they want, assuming that they can let the court know and let us know what they want. Go to the next slide, please. So this is more sort of the quote from that same case where the gentleman didn't want the chemotherapy, and describing, the state's role basically, and the judge's role in intervening in these decisions, which normally we would never know anything about if they weren't under guardianship and in care of the state. So families
Yeah,
make
it's like a good section of the case to show that the courts really strongly feel that they're best positioned to make this agreement and not the guardian.
Yeah, and I think, I don't know if it was Sakowitz, in which when the court makes the decision, they're not supposed to hand the decision to the guardian saying, when you feel it's ready, you can do this. They're supposed to just make the decision and not leave it sort of in the pocket of the guardian to say, well, it's not quite bad enough yet.
Yep, it's the court making the decision. They're really clear about it.
Yeah, and I think that's it takes some pressure off the guardian, whether it's a professional or a friend or a family member, where the court has basically taken that away. That it often can be a burden for family to be sitting there trying to decide if and when to actually change code status. But as soon as the court signs that paperwork, the guardian has to change the code status if that's what the court decides. So go to the next slide, please. So this is just a sort of a review of the factors in Dinerstein. Again, the DNR, which at the time included DNI, and it didn't make that distinction. And sort of describe some of the underlying health problems. Again, early days when we started learning about Alzheimer's disease, distinguished from senile dementia and other names and diagnosis that they used to use for some of this. Again, the family was really involved in this case, and this is the basis upon which, if everything lines up, we wouldn't have to go to court because of this precedent. So I don't know if there's any. If we get the next slide, please. So you can see that Dinerstein, these cases sort of, in some ways, sort of build on previous cases. Here they're referring back to Sakowitz, again, withholding treatment. So to withhold, a DNR is withholding treatment. It's parallel to the withholding the chemotherapy. And a lot of times with the cases that we bring for DNR, DNI, not always, but often it's the doing chest compressions is going to hurt the person, break ribs, especially an elderly person or a medically fragile person, which really is not the goal of the resuscitation. So that often plays into the court's decision whether they're going to actually get injured by getting resuscitation and CPR. Next slide, please. So the Dinerstein, I think on a previous slide, they were saying that at that point, the life expectancy was, I think, less than a year. The doctors were able to sort of give some prediction. And that the courts do kind of look for some of that now, in terms of, I think I'd had one maybe last year where the judge was questioning whether we were there too early. Not that it wasn't probably going to be inevitable that the individual would probably need to have the code status changed, but was it, how close were they to, I don't want to say death necessarily, but were they critically ill enough at that point to be concerned about changing code status? And that's part of what Dinerstein says. And as you can see here, are you prolonging life, but not any kind of quality of life, or interfering with just sort of the natural process of a person passing away? So that, I'm glad it's the judge and not me that has to make these decisions, because they can get kind of complicated. So okay, the next slide, please. So this is sort of more the same of what I was just saying about it's terminal. And typically we look for in the medical records and rely on the team and particularly the nurses is, what is the diagnosis that's underlying this that isn't treatable? Typically it's much better to have something you can say, well, they've got maybe metastasized cancer or end-stage kidney disease or some factor that the judge can then say, okay, yeah, this makes sense, because even if they arrested and needed CPR, the process that's underlying is going to continue. That's why we bug you guys for lots of information.
Yeah, one thing, the quote that's pulled out of this case, the bottom one, the decision is for the medical profession. And it's true, the court makes these decisions and they pull from all the cases, they have pulled these factors they look at. So first, is a person near the end of their life? They need to know that. What's their prognosis with treatment? What's the prognosis without treatment? What would the person want? Is there something about their family or the religion that would make them shy away from some type of treatment? Is there a risk of harm with the treatment, like the chest compressions? And so basically the courts have kind of pulled from the cases sort of all these things that they need to look at, but it's all based on what the doctor says. And as you know, because I'm sure some of you have tried to help us get medical evidence from a doctor, when you ask a doctor to fill out a form, they're not always unfortunately, the forms aren't that great. They're not really geared to end of life. And so the doctors will answer it in kind of a superficial way and not kind of provide the information the court needs to answer the questions. And sometimes that doesn't matter because a lot of judges are more willing to enter these orders without the evidence they're supposed to get. But sometimes we'll say to you, we got to get a better affidavit, or we have to ask the doctor to come to court to answer questions because we know this judge is going to want to know the answers to each of these questions.
And I would say that there are also some courts that they require the doctor to testify.
Right,
so
right.
When I do cases in Hampden County, the judges are expecting a doctor to show up and testify. They can do that via Zoom or on the phone, but in Worcester, I'm almost never needed a doctor to testify. So there is variation in terms of how much information and how directly it might come from the physician.
Yeah, almost all the information comes from the doctor, but sometimes one of the factors that the courts consider is whether the person sort of if they've had a factor that they often look at is whether they can no longer enjoy the things they used to enjoy, if their life has changed. And sometimes we'll ask to have a service coordinator or somebody from a group home to come and say, yeah, that they're just spending all their time in bed. They won't engage with anyone. They don't do these activities that they used to enjoy.
Yeah, that's certainly true. And I think there's also occasionally, it hasn't happened too often, where an individual, that when they end up in the hospital, there's some variation. Some hospitals have their own counsel, most do. And so the hospitals might work along with us and ask us for information about the person, and they might go to court. So we may need to share information with the hospital and hospital counsel if they're going to go to court, or if they're trying to discharge the person but want to change code status so they can return home. So that happens as well. So if we get at the next slide, please. So this just compares a little bit these two early cases. Again, just sort of a summary of the two. And so we've, again, put all the cases together. There's more cases than these, obviously, but these are sort of the earliest ones about withholding treatment. And again, chemotherapy on the one hand and do not resuscitate, do not intubate on the other. Next slide, please. So this is a, I guess, slightly newer case than those two. Again, I think it would help us attorneys if a newer case came along. The trouble with these cases is generally ends up with the person passing away and no one's appealing, because the appeals process usually takes quite some time, so that these cases don't often make their way all the way up to the SJC for them to
I
weigh
feel
in.
like we should explain, Jim, that most of our cases are heard in probate and family court. And those cases often don't result in much of a written decision. They really just result in a court order. And the case has to be appealed. And in Massachusetts, it gets appealed to the Court of Appeals, and then it can be appealed to the Supreme Judicial Court. And those are written decisions with reasoning. And then we use those are in together, those Court of Appeal decisions and SJC decisions are called appellate decisions. And appellate decisions guide sort of, they create law and they guide us. And that's why we're spending a lot of time talking about these cases, because these cases is all we have. And we have to look to them. And as Jim says, you've got to appeal to get an appellate decision. And these cases just don't get appealed that often.
Yeah, I think thankfully often there's consensus among the parties about what direction the case ought to go. So you get an appeal when someone's contesting what the probate court is deciding. So you have to have a record upon which to appeal. Someone's going to say, well, I do or I don't want what the medical profession is saying, and this is why. So that's partly why we don't get many of these cases.
And appeals take as you said before, Jim, too, appeals take a long time, and they take longer now than they did in 1980, that's for sure. And people often die. And if they die, the case becomes moot and you don't get a decision.
Yeah, it's rare for a case to continue. The court of the appeals court, whether it's the regular appeals court or the SJC, would have to decide that, oh, well, yeah, this person passed away, but this could happen again. It's very foreseeable that this would recur. And so they might keep the appeal alive if they decide this is going to happen over and over again. So some decision needs to be made for future cases. But again, that doesn't happen very often. So this I had mentioned earlier about dialysis. This case is at least in part about dialysis. I think that the family and the individual didn't want dialysis. Again, it's quite a process. The person also had some form of dementia. I don't think they were calling it that at that point. It would keep them alive. But again, I think Carol had referred to part of the inquiry as, well, has their enjoyment, the things they used to like to do, the way they used to like to spend their time, has that diminished? Has that changed dramatically? And so being hooked up to a machine for this gentleman 3 days a week, 5 hours a day, and he had some form of dementia, his quality of life had really changed. Dialysis would keep him alive, but his quality of life, they were able to demonstrate that it was so reduced that there was no meaningful future for him to remain on dialysis. And that was also, I think, his expressed wish, to the extent he could do that he didn't want it. So if we have the next case, please. Next slide. So this again reviews a lot of the factors of why we would need to try to go into court. Again, it's always better, not always possible, if we have lead time. If we know someone's declining or had gotten a diagnosis that changes their sort of intermediate outlook, we can sort of prepare a little bit better and gather more information. It is a little bit harder when it's strictly an emergency situation and we're sort of running around. there's always that concern that we might miss some aspect of the person, medical condition or personal life or religious life that would be important in helping us to decide whether to get into court. So this gives us a sort of a list of, based from Spring case, about the factors that we would consider whether or not to go to court. Many of these we've already discussed. So if we could have the next slide, please. So here we've added Spring amongst the cases that I don't know if we necessarily think about them in terms of the names of the cases, but we have these in our heads about sort of cumulatively over time of what we need to think about and under what circumstances we need to go to court. Again, it's rare for end of life to not go to court, except under what sort of they described in Dinnerstein, where the family is the guardian, everyone's on board. Basically, the person has a terminal diagnosis, and so that there is no cure or treatment for the underlying medical condition that's going to restore their health. We could have the next slide, please. So again, another case. There were some high-profile cases back around that time about folks that ended up in just sort of that limbo of being kept alive by medical equipment that probably without them they would have passed. And families, if they don't agree, the judge has to be the one that has to decide, what's, again, the same criteria. What would the person want if they could make that decision for themselves? So that substituted judgment, the judge putting themselves in the position of that individual who is in that state. In this one, at least at the time, the medical ethics sort of pushed this hospital to not want to withhold. And so you don't get that as often as we used to. The thing to look for, that we had a bit of a problem with one hospitalist in one hospital who was making, we thought, inappropriate judgments about the person's quality of life because they had a disability. And that's really, really important to keep an eye out for. We felt that person was just, well, we were unhappy about her decisions to withhold treatment, basing her sort of distant look at the person's quality of life just solely because they had a disability. It didn't seem to be connected to their underlying medical conditions. So you want to be sure that getting enough information is really, really critical. So if we go to the next slide, please. So I think this is similar, where refusing treatment, again, like Mr. Sakowitz, I think that first case, he didn't want to get the chemotherapy, but it was the standard of care at that moment in time. There are cases where, the courts are not going to agree with the individual's refusal, because if there's a chance of a cure or an improvement based on treatment, the court can decide to give the person the treatment even if they don't want it. It's kind of rare because, as Carol mentioned, one of the biggest factors is what does the person want. If they can tell us what their perspective is and what their view is. Look at the next slide, please.
Okay, we can dispense with the dissents, I think, Jim.
Okay, yeah, that's the judges, the infighting of the judges. So
yeah, like
And
we need to
occasionally,
maybe get through these cases because we're 50 minutes in, so maybe we can just.
yeah, I think this slide just reminds me that occasionally, if there is a little bit of a dispute or not, or the judge thinks there's not enough information, or even if we think there isn't enough information, sometimes we'll ask for the court to appoint what we call a guardian ad litem. So that would be, typically it's a lawyer gets appointed to investigate some question for the court. Doesn't happen too often, and usually if it does, it's a quick turnaround. They're asking the appointed guardian ad litem to come back within a week with a report to help the court decide how to make a decision in the case. Again, not too often, but it does happen when the judge will appoint someone to investigate a little bit further. So go to the next slide, please. So this is the policy. We can, if you don't already have this, we can probably arrange to get it sent out, but again, this is going to change fairly soon.
As I said, it's not gonna, the substantive is gonna be pretty much the same, but it will be shorter. But the sort of thing to remember about the life-sustaining treatment policy is that, so it's DDS's policy that we don't consider, is basically a person should not have end-of-life orders until they're at the end of their life. And so a lot of cases that get referred to us, it's not clear that the person is at the end of their life. They may have a chronic condition, but because in these types of cases, the court has to make the decision. They have to be able to know the circumstances, like they're putting themselves in the place of the individual, so they can't make a decision in advance. They have to know the circumstances at the very end of life and decide what that person would decide at the very end of life. So you can't get, like, under our own treatment policy, we can't get an order. DDS doesn't go to get an order ahead of time. And in fact, even if we bring it to court ahead of time, the court doesn't really decide it ahead of time. But so it's always like one of the things that you think about when you're thinking about whether to refer one of these cases to the legal department for us to bring it to court is you think first, does it comply with DDS's life-sustaining treatment policy? So, the continued attempts to achieve or prolong life from the individual's perspective no longer exceed the burdens, and are they at the end of their life?
Carol, can I say something real quick? It's Diana, one of the nurses.
Absolutely.
So one of the things we deal with too on our end, because of all our ABI population, they've had, some kind of accident maybe in their past, and they're fairly young, and they don't have, it may not be like their end of life, but they've made wishes where like they wish never to be intubated again or have the DNR. So those are the cases that like sometimes we struggle with as well, because it may not be according to this treatment policy for DDS, so I think that's kind of where we sometimes need guidance with these folks, because it's just something that they don't want to go through again. And we
absolutely, and you probably know, like, we have an ethicist, and in cases like that where like sometimes it's great to bring in the ethicist and the lawyer, and we can talk about what we can do in that situation. As we know from looking at these cases, like, it's obviously really important that the person have the ability to choose. So those are like it's interesting that you say that, because like none of these cases, they really do, all of the cases that we know about or that the courts have decided have been more narrowly limited to end of life. But it doesn't mean we couldn't ask in the right circumstance when the person isn't necessarily dying, but they know they don't want to be intubated, for example. So that's definitely the kind of thing to bring up with a lawyer.
Okay.
And it also probably matters whether they're under guardianship or not under guardianship, and whether or not they have a healthcare agent or healthcare proxy. So
yeah, so I don't know, do we have a healthcare proxy slide in this slide deck, Jim?
I I think we may.
Yeah, but and we should have said at the beginning, if somebody isn't under a guardianship, none of this applies. They get to make their decisions just like all the rest of us do.
Yeah, but the policy would still apply, but again,
Yeah.
it's worthy of a discussion with the ethicist and a lawyer to sort of tease that out a little bit and how to deal with that. And I think we're going to touch upon the MOLST form here at some point as well.
We're getting to the end, though. We don't have that many slides left. So.
Yeah, that's true.
Yeah.
All right, so if we could have the next slide, please. So here's again the life-sustaining treatment policy. Generally speaking, as Carol said, you got to have a terminal or untreatable diagnosis of some sort. It can't just sort of be speculative. Again, every once in a while, you run across a health professional that makes the decision that they think the quality of life is poor enough to warrant it, but they don't really have enough information. So you always want to review if there's a health professional recommending this, you want to get as many facts as you can about the condition and what the person would want. And again, a little bit about the MOLST here. Do we have the next slide, please?
So yeah, unfortunately, this isn't as this one's a little bit hard to read.
Yeah, I've seen this
done. Walk
better.
us through it, Jim.
So things are a little bit different if the person is hospitalized. Hospitals are allowed, based on their own rules and own ethics and futility policies. How do you decide whether they need to go to court or don't need to go to court? So sometimes you'll see hospitals use something like this to decide whether or not they really need to go to court. Every once in a while, we'll hear cases or know of cases where the person is diagnosed and death is really imminent. There's a lot of, let's say, organ failure, and so they know there's no question this person's not going home. This person's not going to leave the hospital.
So I know this chart is a little bit hard to read, but if I could just step in, this is just the chart to show you why we have to go to court so much, right? So the Mental Health Legal Advisors Committee originally did this chart, and they're the people who get appointed to represent people under guardianship when we go to court. And so whenever you have an incapacitated person, you can see, if you follow the arrows, if there's a chance of recovery, it has to go to court. If there's the only time, so all the arrows bring you back to having to go to court, right? You can see that. If there's a chance of recovery, if there's no loving family members, or if the family members don't agree, or any time like that, like if there's any disagreement at all, then it always has to go to court. And the only time it doesn't have to go to court is if the person's terminally ill, the family members are in agreement, they all agree with the DNR, and then you can put a DNR in place. And like I said, sometimes you might be able to do a DNI. It kind of depends. You have to talk to the lawyer. So this chart sort of illustrates like really you have to have a lot, like it has to all work out for you to be able to get it to not go to court. And that's why so many of these cases end up in court. Right.
And that's why we often will bug you for the referral form, because we need to know who the family is. Because if there's someone who's entitled to get notice if we go to court, then they could object. So we need to try to see if they are agreeing with the decisions that are being made. And again, I don't think it specifically says this on this chart, but the guardian has to be a family member.
Yeah, it has to be a family member guardian, right? It usually, it may not say that, but it has to be a family member guardian who's making the decision.
Yeah, and so the family again would have to agree that usually means the immediate family. And you don't want the fifth cousin saying they disagree, but siblings, parents, just the close family. If you think someone's going to have a different opinion, then we probably have to go to court.
Yeah, actually, that's so one of the a good way that when we get one of these case referrals, it's a kind of a lot of times we ourselves, or we might ask you to contact the family members and make sure they understand what's going on and get their opinion. So we know in advance, like, are they going to agree or are they not going to agree?
Look at the next slide, please. So again, we've sort of mentioned this of what we need, how to start this. The more information we have, the better. And the sooner we know, the better. So
yeah, I would say like the thing that slows us down the most. There are two things that really slow us down when we get a referral. It is one, that the medical evidence isn't very good. Like lots of times you'll help us, you'll ask a doctor to fill out a medical affidavit, and it really just won't have, you can see that for us to win these in court, we have to give enough information that the judge can make this substituted judgment decision. And they need to know a lot of things about the medical history, especially because they have to know, like what are the treatments, what are the side effects from the treatments, will the treatment improve, will the treatment not make it much of a difference? So they need a lot of medical evidence to be able to make that decision. And the other thing that really slows us down is because we don't have unfortunately, a lot of our records, we don't have all the family members. So we're required to give notice to who a family member is defined by statute in Massachusetts, and includes like mother, father, siblings, half siblings, and then there are it can include cousins and nieces and nephews. It just sort of depends. Like lots of times there won't be, the parents will be dead, and we need to notify all the siblings. And if a sibling's died, we need to notify the siblings' children. And lots of times we don't have that information. And so that really slows us down because we have to figure out, because those people are entitled to get notice as part of due process. And so we got to notify them whether they're interested or not.
Right. Yeah. And I think Carol mentioned before, sometimes the medical certificate or the affidavit from the doctor, I've once in a while had to send them back just because they just didn't have enough information to go forward on. In some ways, like Hampden County, I've got one coming up this week where I know the doctor's going to have to testify, so I didn't really send it back. It was kind of weak. It passed getting filed, but she's going to testify on Friday. So I'm not as concerned about her documentation because she's going to explain to the court directly, what she thinks about the case. So that medical information is going to come in when she testifies. So we get to the next slide, please. So Jim and I actually, as you may know, we stepped in to do this training, and the slide deck is a little bit different than the legal department has some different slide decks. So we had hoped there was going to be one on healthcare proxies. I guess we have the one without the healthcare proxy, but we can quickly tell you, Jim, do you want to take that and talk about why lawyers love healthcare proxies? Sure. So the primary reason is you almost never have to go to court if there's a healthcare proxy. The healthcare proxy, as most of you probably know, that's the individual presumed to be competent choosing who they want to make their medical decisions in the event that they lose capacity and can't make any decisions. So in a car crash or they have some medical event where they cannot make medical decisions, they pick someone to make it for them. And they can, in that document, limit and put specifics down. I do want resuscitation. I don't want intubation. They can specifically say what they want and they don't want. And then it requires a physician, a licensed physician, to decide that the person now lacks capacity, so that they can no longer make medical decisions for themselves. And then the healthcare agent can now make decisions for the individual, what they would decide themselves, not what the agent would want. So if the individual fills out a healthcare proxy and says, I never ever want any kind of chemotherapy, and it turns out that the person develops some kind of strange cancer but can't communicate their wishes, and the healthcare proxy is invoked, the healthcare agent is stuck with what the individual instructed them to do, not what the healthcare agent wants. It's what the individual would want. So they act on their behalf, not in their best interest. And the only circumstances that I've ever ended up in court for a healthcare proxy, a person can revoke a healthcare proxy verbally. So they may have lost capacity and then decided, well, I don't want my aunt to be my healthcare agent, even though it's already invoked. Sometimes you have to go into court to have the judge decide, well, they didn't have the capacity to revoke that because it was already invoked. So there are some limited circumstances where you have to go into court to either get it validated, or if you can't, we've had a few cases where the healthcare agent is unavailable or decides they don't want to act. And then you have to go the whole guardianship route. But
so quickly about healthcare proxies, you probably have all seen the document. There's kind of a form document that a lot of people use. You don't have to use the form, but there's a law in Massachusetts that governs healthcare proxy, and you might not have to use the form, but you have to have all the required elements. So you have to name an agent. The agent has to sign that they agree to be the agent. I think
you have to have two witnesses.
You have to have two witnesses, right? So you have to have all the elements that they say you have to have. And whenever you get a healthcare proxy, you can send it to any of the lawyers, and we can look at it and tell you whether we think it's valid or not. So if you have one, they're a simple document, but still, it's good, good to practice to send it to us, and we'll say, yeah, it seems valid to us just by looking at it. Sometimes we need information though, because a common thing that happens is that a person will, I think a lot of times when somebody turns 18, their parents want to get guardianship, who's somebody with a intellectual disability turns 18, parents want to get guardianship, and they, at the same time they file for guardianship, they have the individual sign a healthcare proxy, and then there just might be a question about whether the person had the capacity to sign. So sometimes we might have to ask you questions like about the circumstances of the signing of the document, but we can look at it and give an opinion about whether it's valid or not. And then we also should touch on the MOLST. And then I actually think we should let Diane tell us about the 5 wishes, because that's actually a really good thing to know about. But first, let me just say about MOLST forms, because I feel that there's so much confusion about this. So one thing we took you through lots of court cases, and the only thing the one rule we can extract from the court cases is that a loving family member guardian can enter a DNR. And that doesn't change when someone's filling out a MOLST. So when you fill out a MOLST, that's why they can only fill out Section A if they're a loving family member. And no one else you can't fill out any other parts of it, because if a person's under guardianship, the court has to make the decision. And again, with MOLST, you should send them to the legal department. And there's actually a little cover form you fill out so we can tell if it's a family member, and you send it to us and we say, yeah, this MOLST is valid, or no, it's not. You need to, this is what you would need. Maybe we can have Diane talk about the 5 wishes.
Yeah, just real quick, one more thing about MOLST. We had one sort of tragic case. You don't want a MOLST that's a full code. We had the one tragic case somewhere, I think it was an IDD person, where there was a MOLST and the EMTs assumed it was a DNR, DNI MOLST, and it wasn't. So they didn't immediately perform CPR, and I think the person
They
passed
saw the
away.
pink paper, right? Yeah.
Right, they just made an assumption about it, and they should have looked at it.
So Diana's going to tell us about the 5 wishes, which would be great. And even if you can't get the 5 wishes, if you could just note somewhere if you're providing services to an individual and they tell you something that they want to express a wish, if you just note it down anywhere, it could be really helpful to us.
Yeah, I do think that the 5 wish packet is super helpful, especially in our ABI MFP world where we have a lot of young people getting into accidents, a lot of even, mid-age people who are very healthy and have years and years to live, but they don't have a proxy or they don't have any wishes jotted down, right? They either had a sudden stroke or an accident, and then here they are in our waiver. We do have, we get them from central office, I believe. I would recommend every office having them. We have a bunch, and we try to hand them out when people move into our group homes. I mean, if they are their own guardian, and if they do not have a healthcare proxy, maybe it's something they never thought about before, but simply it's a blue packet. I did put the link on the chat for you guys to look at the sample. I actually have one for myself, and sometimes I'm the life of the party because this is what I talk about when I go to a party, right? I'm talking about but it's seriously like it just kind of goes into one of the first things is who do I choose my healthcare agent, so you can put up to actually 3 names on this form, and they have a bunch of bullet points that goes really deep into what you want for your end of life. It's actually a little more in depth than a multi, I feel like, because it really goes into like, little things like, do you want music playing at the end of it, while you're passing away? It goes into like little things that you didn't think to ask somebody, I guess. Whether they want to pass away their home, whether they want to have, like I said, their favorite music being played, if they want pictures of their loved ones behind, like near them. It really goes into detail. And I think a lot of our people that are their own guardian, we have been trying to help them fill this out. We've been letting our providers know, whether it be like the house manager or the nurse that sits down with our people and kind of just, you don't have to get it all done in one day because it is very overwhelming. So maybe even having this as like an ISP goal would be a good idea. So yeah, the link is on there, and I definitely would recommend having this in the office and sharing it with folks who may not have a proxy, just in case things were to happen down the line. It would avoid going to court for a court-appointed guardian if they have somebody in mind that they could have as a proxy.
And even if you have to go to court, it's a place where they could express their wishes, so that we would be able to say to the judge, this person absolutely did not want to be intubated or whatever, because as you can imagine, a lot of cases we don't actually have a lot of information. So it's just really helpful. And your idea about reviewing at the ISP, so we ask, I think one of the things you're supposed to think about at the ISP is this, and that it is a good time to make sure you know all the family members. And I know it's a hard topic to talk about, but if you can, it's really helpful because as you know, a lot of times the way these cases come is a real emergency, and we're all just scrambling to get information. So anything you can do in advance is really helpful. We actually added something to the form this year too about religion, because religion actually has come up. We've had a number of Jehovah's Witnesses who have as you know, have particular opinions about blood transfusion. So that's actually helpful. If somebody if they're Jehovah's Witness, or if they have some other belief or something that they that's maybe unusual and we wouldn't think of, it would be really good that if we could know that. So are there questions?